6 o'clock, we'll call the meeting to order. Please rise for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Approval of the agenda. Do I have a motion to approve the agenda?
Motion.
Support. We have a motion and a support to approve the agenda. All in favor signify by saying aye.
Aye.
Aye. Any opposed? Motion carries. Approval of the minutes. Any comments on the meeting minutes for the last two regular planning commission meetings? October 8th and November 12th.
I am absent.
Yes.
Yeah.
Me too. No comments? So I guess we'll just do them individually. Do I have a motion to approve the October 8th regular meeting minutes and public hearing minutes? So moved.
Support.
Kevin supported. I have a motion and support to approve the October 8th regular meeting and public hearing minutes. All in favor signify by saying aye.
Aye.
Aye. Any opposed? Those minutes are approved. How about a motion for the November 12th regular meeting minutes? So moved.
Support.
We've got a motion and support to approve the November 12th regular meeting minutes. All in favor signify by saying aye.
Aye.
Aye. Any opposed? Those minutes are approved. Now we'll go into call to the public. This first call to the public session is for agenda items.
Jeanette Ropetta, Tyrone Township resident. My first public comment is regarding agenda item 11, where you have, sorry, I forget what item it is, but you've got 11 items on it. The environmental study and also the conditional rezoning, number 6. I'm tying them in. I can't tell what those are about because there's no documentation on them, but I can certainly tie them into an excerpt from a memorandum by Dr. Remington Nevin, the medical director for St. Clair County. Dr. Nevin highlights significant public health risks associated with solar plants, and that connects to both the environmental impacts and the standards we set for zoning decisions. So that's how they tie into the agenda. I want to share some excerpts from that memo. Again, he is the St. Clair County Health Department Medical Director. His name is Dr. Remington Nevin. He released a memo, and he said he went to regarding the November 7th Environmental Public Works Committee meeting at the St. Clair County Board of Commissioners. He recognized public concerns, and they were raised regarding the potential health risks posed by the proposed construction and operation of certain industrial solar plants. He says, in my professional medical opinion, based upon my education, training, and experience, my review of the pertinent facts, he says that they constitute a potential public health risk, and they're therefore subject to local public health oversight and action. So this is a 7-page document. I won't read it all to you, but he does say several times in his professional position and his opinion, he cites many reasons why the Public Health Department has to come forth and make a statement and take control on this. And as you know, the government gave our public health departments a lot of power during COVID, right? That power still stays with them and they are able to make decisions. And he is saying that these need to be governed by the public health departments of counties. So what I'm asking you guys, these serious concerns raised by Dr. Nevin about solar plants, it's something we can't ignore, and his recommendations are valid. Tyrone Township residents deserve those same protections. So, you know, I think it's worth asking, how can we encourage our own Livingston County Medical Director to look into these issues like he has? I'd like to see the Planning Commission take the lead here. This is about protecting the health and welfare of our community, which is a big part of your role. And we need to make sure these health risks are being taken seriously. So I hope I receive an answer to this. Would you bring to the board's attention and ask them to join you in reaching out to our own Livingston County Medical Director and ask that he consider Dr. Nevin's memo and consider adopting a similar approach? And if any of you want a copy of this, it's kind of hard to find, I would be happy to email it to you. All you have to do is reach out and I'll send it to you. Thank you.
Thank you for the comment. Anyone else? No further comment. Moving to old business. Item number 1, extractive industry. We have Mr. Fisher here on the Zoom call as special counsel to help us with the extractive industry ordinance. Last meeting, we gave him some direction on changes to make. And I guess one thing I had, Ross, was what is the schedule on this? From my quick research, the moratorium is going to expire next week. Is that correct?
I'll need to verify that. I think that we have more time on this one, if I'm not mistaken, but I unfortunately don't have that date right in front
For
of
my math, it was it's going to be next week on the 15th.
me. Okay. We'll try to get that.
So that's kind of plays into, I guess, our timeline, and we still need to have a public hearing on that, right?
Correct. Yep.
Okay.
So we can communicate to the board that we should get that moratorium extended if that is in fact the case.
All right, Mr. Fisher, can you give us maybe just a very quick high level of the overall process, and then a summary of the changes that you made since the last meeting?
Sure. Nice to be with all of you again. The process will be that the Planning Commission will conduct a public hearing. You've got to notice it and provide 5 advance notice and published and all that. And then you will have your public hearing, and either at that meeting or the following meeting you can make your comments and recommendations to the Township Board. And the ordinances, amendments would go then to the Township Board for review and either modification or adoption in the form that the Planning Commission sends over. And then the clerk will publish the ordinances, and they will become effective unless somebody files an application or a petition for referendum, which is very unlikely. So that's a high-level overview of the procedure. With regard to the ordinances, I believe that we completed our review of Article 19, which is the basic special land use for zoning approval of a mining operation. We also took up at the last meeting Article 17 of the zoning ordinance that relates to an amendment to M2 Heavy Industrial District to authorize concrete crushing. And then we also, the more lengthy work that we did last time was ordinance number 21, which is the extractive industrial ordinance for the operation, for an operation. And this ordinance will come into play only after an approval is given under Article 19. Any questions about any of that?
Yeah, Chris?
I had just one question, Mr. Fisher. I'm Chris Ropetta here, and
Hi, Chris.
I'm new on the Planning Commission right now, but just regarding Article 19, I just had a really quick question. Several times, such as in Section C, number 4 and A, around existing land uses, there was a statement that said, following are some but necessarily all examples of considerations relating to potential existing land consequences. I was wondering if that was out of the law, extracted from Act 113 verbatim, because it seemed to maybe me missing a word like following are some, but not necessarily all, and that's repeated. I wasn't sure if there was
And this is Part C?
Part C, and then number 4.
Did you say B or D?
C. Charlie.
C.
Charlie.
Yeah. C4.
C4, and then A.
Oh, yeah.
So,
Well, that was quite an intentional insertion here, because the Act does not essentially say that these are the only considerations that can be made. You know, and it was my view that that something could come up that may not fall into one of the nice, neat little bundles, and you may want to take that into consideration. I mean, if it's something that creates a nuisance or harms individual properties or endangers traffic, etc., I didn't want you to have your hands tied and not be able to consider it. There isn't anything specific in the ordinance that this refers to, but it's really something that conceivably could come up at a hearing.
okay, but so should that in parentheses say, but not necessarily all, instead of but necessarily all, or is that worded specifically to ensure what you just said?
Now this is it's under. I'm trying to find this line. Oh yeah, following are some. Yeah, but not. You're right. Absolutely right.
And then it's repeated in a number of other places forward through the document. And just for clarification, I just wanted to make sure it was the intent to say this is a sum of them, but not necessarily all.
Yeah.
Okay.
Yeah.
Yeah, the exact point that he mentioned. You don't want to say this is.
Right, exactly. So, okay. So if that correction, and there's, I think, at least four places with the same exact verbiage that I saw, so.
Okay, I'll take a look at it, see what I find, and make the modifications and send them to Ross.
Thank you.
There's 5 spots.
5.
5 of them. Yeah.
5 spots, sorry.
I can give you the spots if you just do a quick control.
All right. Anything else?
That was it for me, thank you.
All right, then I've got the other two ordinances to discuss here, are amendments. The first, which is the shortest, is Article 17 of the zoning ordinance, where we have are amending M2 Heavy Industrial District to provide a special land use for concrete crushing. this was before you last time, and what we did is expanded the language to clarify that the only time this could be approved as a special land use would be that as part of, as an accessory use to a mining approval under Article 19. So in other words, no freestanding concrete crushing operations as special land uses. And that's the only change we made in that ordinance, or that amendment.
Do we have that?
That, so that's gonna basically put it to what we had previously, right? Crushing is only allowed with the extractive industry.
That's exactly right.
So, okay, so I
Yeah.
think that was what we discussed last meeting. I think everyone's on board with that. Yeah, then we're allowing someone to come in with just a sole concrete crushing operation.
Right. Nothing freestanding.
Yeah.
All right.
Any comments on that, article? From the planning commission? All right, thanks, Mr. Fisher. You're moving on to, 2021?
Article, or ordinance 21, yep, we've got a few changes that I can run through quickly.
Okay.
On the first page, under section 40.102, the purpose, we made a clarification here that an application for a mining permit under this ordinance shall not be considered for any property which has not first been approved for mining under Article 19 of the zoning ordinance. The way it had been written was that it would have been conceivable to have these applications running concurrently, and the desire of the planning commission was, no, we're not going to do that. We're going to wait till we finish under Article 19 of the zoning ordinance, and then somebody can file here. And which makes a lot of sense. It doesn't, in case there's a denial, there's no waste of time to be going through this one. The next change occurs on page 4, which is under article or section 40.107, submission, review, and approval of permit applications for the extraction of natural resources. And in this section, the way it had been written previously was that it would be a hearing and consideration only before the township board. And the planning commission, I think wisely, determined that you want to get your oar in the water before it goes to the township board and provide your recommendations, because there is a lot of land use stuff here. And so I broke these sections up, starting at the bottom of page 4 over to the top of page 5. So we provide that the planning commission will review and make a recommendation first to the township board. In other words, you're going to have a meeting and discuss it and review it. And then the planning commission will make its recommendation to the township board, the board would then conduct a public hearing and go from there. The next modification is on page 8, and I did send a correction on this one. It's on page 8. We had a discussion about explosives, the use of explosives, and the desire was to prohibit explosives. So what we did on page 8, paragraph 10, was insert a confirmation that explosives are not proposed to be used as part of the operation. On the next page, this is just a clarification. I think I had external agencies approvals, and we wanted to make sure that everybody understood that they could be county, state, or federal, and federal. And so I inserted that on paragraph 17 on page 9. Moving over to page 11, paragraph 15, and please stop me if there's a question. Paragraph 15, and this was a complete addition that we discussed at the meeting. It hadn't been in the ordinance at all, but in the event there's a violation that exists, the owner cannot transfer the property to one or more other individuals and absolve themselves of liability, so that they will remain liable to cure the violation. Now, of course, it may be cured by the operator that they transferred to, but the prior owner will remain liable until it is cured. Over on page 12, hours of operation, we clarified that your desire is to have these operations start no sooner than 8 o'clock a.m. And that's on Monday through Friday and as well as Saturday.
Go ahead.
Hey, Mr. Fisher.
Yeah.
Yeah, I have a question concerning the liability on number 15, page 11.
Okay.
In instance of bankruptcy, what happens to liability at that point? Where they have no choice but to...
Unless it's something that happened intentionally,
Right.
which is certainly unlikely, the obligation probably gets taken out. In other words, any financial obligation would be removed, presumably.
In that case, is there a way to transfer that liability?
Well, I mean, the bankruptcy affects a lot of things, but conceivably what we could do, it depends on the timing. When a bankruptcy petition is filed, there's somebody known as the trustee in bankruptcy.
Yeah.
And the trustee might be able to go against the estate of the bankrupt and get the money that was paid for the operation if it was sold.
Even if it's a protected corp or LLC?
Yeah,
Okay.
yeah. There are certain doctrines in bankruptcy, and I'm no bankruptcy expert, but I taught some of it in law school when I was a professor. There are like 3 or 4 or maybe 4 or 5 instances, or maybe more, in which the trustee in bankruptcy can set aside the transaction and get the money. For example, if it was a fraudulent transaction, in other words, if they sold it, got the money, and then did something with the money and then went bankrupt, they might be able to trace the money and get it.
I'm just trying to figure out ways that we could tighten up number 15 a little more. Are you aware of any other ways that we could tighten it up?
Well, one possible thing is that if there is an outstanding violation, although you'd have to find out about a sale, we could put a provision in here saying that prior to any sale, the owner would have to escrow sufficient money as determined by the township engineer to cover a cleanup.
What's the standard amount one would put in escrow at time of sale? And obviously, it's depending on use case. But what do you think is a sufficient amount? I mean, is this something that deserves an amount? Is this something?
Well, yeah. I mean, what would happen what would happen in that situation would be, because the violation could be almost anything. It could be something that would cost $2,000, or it could be something that costs $50,000.
Right, exactly.
And so what would normally happen in that case, if we wrote it this way, is that the township engineer would make an estimate of what the cost is, and then the owner would have to escrow the money.
What if there was like a requirement of, let's say, like an umbrella insurance policy that they could go after if something like this happened, as like an exception?
You mean an insurance policy?
Requirement.
Yeah, but at what point in time? At the time of the sale?
At time of sale. Yeah, at times, throughout ownership.
Oh.
From time of sale throughout ownership.
Yeah, what we would have here is, and this is at the end, we have performance bonds, which would be a little bit more typical in a situation like this, is a performance bond rather than an insurance policy.
Yeah, bond, that'd work too.
Yeah.
Yeah. Yeah, upfront.
But you wouldn't really know how much it should be until you knew that there was a violation and a potential sale.
Right.
So I don't know, and I don't know if you could keep it in place for the entire duration.
Right.
One of the things I have in here is that the bond would be, there are 2 or 3 different kinds of bonds, but one of them is just for the performance of various things throughout the process.
Sure.
And so that would certainly, and I guess we could put an item in here for curing violations.
How do you guys feel about it? Would you see
The
something
way
like
I
that?
read it, the performance bond would cover that, but I guess you don't think it would.
At that time,
Because
just,
it's part of their performance.
yeah, but this is more,
Page 17, it's reviewed biannually.
this was like an actual violation. I'm just trying to figure out, performance bonds I thought they were a little different than that. So, one point that Rich brought up was he thought that was at page 17 talks about a performance bond.
Yes.
Would that cover it?
Yeah, it would. It would.
It would? Okay. I was wrong.
I think we could put a specific provision there, including the cure of violations.
Okay. No, I'm okay with that. Do you guys see a problem with this, anybody?
I think whatever Mr. Fisher recommends, if he
Yeah.
thinks we can add something in there to help protect it, I don't think it can hurt.
Right, I'm just trying to tighten that up and kind of help everybody at the end.
Okay. Should I go forward?
Yeah, we can go forward now. Sorry about that. I just wanted to
Oh, no problem. That's a
get
good
this
idea.
clarified and.
Yeah. So moving on, and on page 15, under paragraph 16, that there was language in there about the use of explosives being regulated by the state police, and we just, because we're not allowing explosives, we just took that out. That was just a deletion. And then under paragraph 17, added a provision about lighting, that the lighting utilized would meet all non-residential lighting standards and specifications and township regulations intended to avoid unreasonable off-site impact. And then a provision in paragraph 18 that was desired of not allowing the property to be occupied for residential purposes during the course of the mining. And so that's been inserted. Over on page 16, section 40.110. I've reworded that language. I didn't really make any real changes. It just flowed a little better with some rewording here. So while I had my mechanic's outfit on and I was under the hood, I just thought I'd make that change. And then under violations on page 23, we changed the amount of the fines. First offense was moved from $500 to $1,000, and repeat offense was moved from $1,000 to $2,000.
Can I ask a question about that, John?
Yes.
Mr. Fisher, is the offense, the fines that are specified that were negotiated last time, does that give us more of a penalty-based deterrent rather than I know we talked about a criminal-based deterrent if we wanted to make it a criminal act. But is it about the deterrent is the most important thing? And does that sway the opinion of whether or not it should be criminal charges for such a violation versus financial penalties for the violation?
Okay. Yeah, that's a great question. That's a great question. And the answer is going to be it'll affect different people in different ways. But the real problem in my mind for making something like this a criminal penalty is that, first of all, the court is not going to like it because they're going to say, why is this a criminal penalty? Why is this a crime? And that's why civil infractions were created in the first place. That's going to be one of the reactions of at least some judges.
Didn't we discuss if it was civil or a circuit court? Because I want to say that we discussed this before.
You can go to circuit court no matter what.
Right.
And so you can get an injunction. But if it's a criminal, what happens in that case then is the first thing you get is an attorney will come in and demand a jury trial, and then go through a very, very lengthy process. And it'll really tie things up so that you're not able to do very much enforcement until the case is over, and you never know what the outcome of the case is. Whereas with these civil infractions, if you look down, have you got that page 23?
Yep. Yeah.
Andy, under paragraph F, like Frank, in addition to any remedies provided in this ordinance, any equitable or other remedies available may be sought. And what that means essentially is that a district court judge, if there's something that the property owner should be correcting, the judge has the authority to order it to be corrected. And if it's not corrected, they can hold somebody in contempt and, if necessary, put them in jail. So this is a pretty powerful thing.
Okay, I just know that, and in your experience then with this extractive industrial, would you say that there are, what's the proportion of instances that the ordinances may be civil rather than criminal?
Yeah, modernly, yeah, and I was involved in a state bar committee that created the civil infraction penalty, and the reason is that it seems to, it's like, it's the penalty that fits the problem, and modernly most communities redoing their ordinances or doing new ordinances make these things civil infractions.
Okay. Thank you.
Sure. That's a great question, though.
I just think a criminal deterrent would be more of a deterrent than a company that's making lots of money extracting, paying fines on a daily basis could be less of a deterrent, but
Yeah, well, yeah, there's no doubt about that. And where it really becomes a serious thing and they're not complying, that's when you go to circuit court and get an injunction, try to get an injunction right away.
okay. Thanks.
Yeah. Okay, and I know Ross wanted me to mention to you that what's going on in the Michigan legislature. The industry, the aggregates industry, is attempting to remove all authority of local government to do this kind of regulating. And they've been doing it for about 8 years now, at least. And we have now this session called the lame duck at the end of an election cycle. So you have people that will not be coming back that can try to make law between now and the end of the year. And they're called lame ducks because they have no liability or responsibility for it. And the craziest things happen in lame duck. Now, so they introduced a bill on November 14, which is awful, and it essentially gives all the authority to Eagle to issue permits and all that kind of thing for this kind of operation. We've been fighting it pretty hard, and we fought it in the last 3 lame ducks before this. And so far, so good. The report that I get from the lobbyists right now is that the legislators that might otherwise act on this are disorganized because of, for whatever reason, the end of the year or whatever. And they are not getting quorums at their committee meetings to try to push this forward. They had a meeting scheduled last week and canceled it because of that. And hopefully that is going to continue. They only have, like till before Christmas. And if it's got to be approved by a committee in the House and then a committee in the Senate. And between those two, it takes 5 days. You've got to let it sit on the table for 5 days. So even if they did something this week, it'll be pretty darn close. They'd have to rush this thing. So the lobbyists seem to be somewhat confident that this is a low probability of being passed. And I hope they're right. Okay. Anything else for me?
So, I guess, quick question, where we're at right now, you can kind of determine if you feel like after he makes those changes, we're ready to schedule for public hearing, you can instruct me to start setting up the public hearing. It doesn't need to be a motion, but you could do that. The other option would be, when it makes the revisions that were discussed tonight, we could potentially review them as early as our workshop meeting next week, assuming that he's able to complete that by
Yeah, I mean, I don't know what the board's planning on doing, but, I think the moratorium expires next week. So I think we need to get this moving forward.
Yeah.
We got comments in here, we gotta make sure that we're,
So we just want to have the subcommittee verify once the adjustments have been made that.
well, can't we just, the whole planning commission review it next week? If you can make it in time?
Yeah, there's 2 options. You could say.
Yeah, I would try to do that.
Go now subject to the revisions being made and confirmed by the subcommittee, or we can confirm them as a planning commission at the workshop.
I mean, historically speaking, we'll get this by 8 o'clock.
Yeah.
Tomorrow morning, or tonight.
So, yeah, I think you can, because you can make small changes,
Yeah.
right?
Yeah.
I mean, these are very small changes. So in my opinion, I think it's worth moving forward
do
and
it.
setting up the public hearing. What does everyone think?
January meeting?
Yeah. I agree.
Yeah.
I mean, you gotta, yeah, so that'd be for the January meeting.
Do we have any applications right now for extractive industrial that would
Well,
compel us
it
to
was
move
on
faster?
It's on
It's a
moratorium.
moratorium.
Oh, it's moratorium, that's right.
But that expired, in my calculation, 180 days from the day that it was passed is next week.
It wasn't set up for 6 months?
Yeah, I'm pretty sure. it was-
No, it's not, it's 180 days.
Was it?
That's what threw me out, 'cause I thought it was.
But I could be wrong. I might have it mixed with the marijuana, which I think is expired, but stand by. Extractive industrial, oh, that's permits?
Doesn't hurt to see.
Yeah, and I just don't know what the plan for the board is, if they want us to keep working on it, because that schedule that was originally set was like last month, or 2 months ago.
Supervisor's here.
So I don't know what the budget was and all that, so.
Yeah, I'm pretty confident that it was a 6-month moratorium for the extracted, so I think
Okay.
we're in good shape on that. I do know that we need to talk about the medical marijuana, but that's gonna be in our action list discussion as well, so.
I just don't think we want to keep making small changes every meeting,
Oh, no.
you know, and we'll drag it on.
Yeah. So, I mean, if you're happy with it after that, then, you know, we can talk about it at the workshop, and I'll plan on making sure we get notice out on time for the January meeting.
Sounds good. Thank you, Mr. Fisher.
Okay, my pleasure. Let me know if I can do any more for you on this as you move forward. Any questions or whatever. Be happy to do it.
But actually, I do have one question for Ross and maybe you, Mr. Fisher. The regulatory ordinance, number 21, is that
Yeah.
something that the planning commission still has power to make a recommendation?
You can recommend it to the board, but the board.
Yeah, you can
I mean,
make
we
a
can recommend
recommendation.
anything, but it's not-
It's not as formal as in the zoning ordinance
Okay,
situation.
understood. That's what I thought.
That one doesn't go through
Yep.
county review or anything.
Yep,
That's just
understood.
through the board.
Everybody wants the planning commission's wisdom, though.
Yeah, okay.
So last question, Mr. Fisher, do we want him to attend our workshop? Do we think that that's necessary next week?
I would recommend it, but I don't know how many meetings we had planned for him or whatever. I
If
think
you
we can
happen to
afford
be
it. Let's do
available
it.
next Wednesday at 6,
Next Wednesday the 18th at 6, yeah, I'm available.
okay, then let's shoot for that, and we can do it Zoom or in person, whatever you prefer.
6 o'clock. Okay, well, why don't we, you just let me know what everybody would prefer to have.
Okay.
Oh, that one is 6 months.
It is 6 months,
I've
okay.
got,
But that was
I
from,
don't have another meeting.
April
tonight.
April 16th.
So, that one's close.
Okay,
Great.
all right. I'll talk
Thanks
to
a
you.
million.
Yep, thank
I think
you.
it was the marijuana that was.
Bye-bye.
Yeah, Ross, it looks like the extractive industrial moratorium is 6 months from April, so we have until January.
We're okay on that.
Oh, no, wait, that's passed. That's passed. That was, we've been off moratorium for 2 months now. Right? April 16th,
Yeah.
6 months, so that one expired. It's the marijuana one that I think expires next week.
3.
Yeah,
We can continue, don't mind me.
okay.
You're moving this one, yeah.
All right, so, next item of business, new business, item 1, planning commission action list. So this was, just kind of a rough list of some things that we've either started, we've been given direction on, or have been on a list since prior to me being on the planning commission. I don't know, Rich, some of these, I mean, we could go through the list one by one. But I think it's just a start to gather our actions until we either have a joint meeting with the board and get further direction. So starting with, and I don't think these, right now, they're not in any current order.
No,
Although
but I can provide a brief summary and background on each each item as
Go ahead,
necessary.
go ahead, Ross.
So, but before I get into these items, one thing is, at the last board meeting, they did approve both the renewable energy text amendments as well as the overlay map. However, we may need to revisit the overlay
So
map.
that might go back
to
on
add
the list.
additional area. So I would recommend that we probably consider that a top priority because it's ongoing and it's a time-sensitive issue. Because as of the board meeting, Laura advised that it does not currently contain enough land area based on the changes that they've made. They've now specified that we need a minimum number of acreage, and we're not meeting that. We need another 150 acres, I think.
Okay,
So we will want to start focusing on that. We'll need to have Laura involved.
but that's not in the law.
It is.
That's in the,
That's how I.
It is.
that's in their interpretation of the law, right? It's not in the text of the
Well,
law.
originally, when we opened it up, when we started, when we got everything going, it was not, but it had since changed to now specify a specific number of acreage, which is 250,
50.
I
It's like
believe.
250, 260.
Somewhere thereabout.
Yeah, I think it would be good because the county, you know, we haven't really reviewed those as a planning commission, so
Right.
I think we're,
Well, we can do that at that time.
Yeah, I think
Take
so.
a look at what the county recommended, we'll get Laura back involved and.
that's what I was gonna say. If we, once we get into that one, I would prefer Laura to be here.
We absolutely will want to.
And
if you so
in person
choose-
is preferred, I would say.
Yeah, and if I can get her lined up for next Wednesday, I mean, we can even start then, depending on, you know, how you want to.
That's, I guess that's up to the board. I don't wanna just call an attorney, every attorney to every single meeting.
That's what they were hired for.
Okay, all right.
So, I mean.
The
we're only-
supervisor here, ask him.
All right, so Ross, go ahead with the, action list.
So, number one on the list here, and again, these aren't really in a particular order. We have the Michigan Medical Marijuana Act caregiver regulations, which is a sensitive topic. We've had a number of applications. We don't have anything currently. We did have a moratorium in place. We may be extending that moratorium to just kind of reevaluate. We've gone over this. I mean, we've amended this section, I think, at least 3 times since the MMA went into effect. However, as time goes on, there's more and more case law, more things to consider in terms of what we actually have the power and authority to do. So the intent of that is to obviously take a look at the current standing of the law, of current, or the latest case law, and see if we can add more teeth to it.
The way I understood the way we left that is what the thought was that we would restrict it to commercial.
Right.
And I don't know if there's been any interpretation
Yeah,
on
and
that
that's
or
what we're
not.
gonna need to kind of research and look into, and it's gonna be up to the board whether they want to actually hire somebody on to assist with that, or whether we just go through our planning consultant and our township attorney.
Yeah, so that, but that was, we weren't allowed to restrict it prior to that case law, right? That's my understanding, and now
That
we,
was- that
now
was
we
the
can
inter-
restrict
That
it.
was the general interpretation,
Okay.
yes.
Do we still have a lawsuit that would affect our ability to pass or address the
That
ordinance?
has nothing to do with, that would be a separate issue if there's a lawsuit.
Okay.
So on that one, do we, when we want to have council talk to us, is that our general counsel or is there a special one?
Well, the board can hire a special counsel
But-
if they choose. If not, we'll default to our township attorney and our planning consultant.
All right, but isn't Laura specialized in that too?
Yes.
In the marijuana?
Yeah.
Possibly,
I
but
believe
I
she
don't
is.
think that we have her contracted.
I know, that's, I don't know if she can talk to us about
That's something that,
anything. But anyway, I think that we would want to have counsel on that.
that's something the board's gonna need to determine, and that's
Understood.
something that I'm sure that they will discuss and consider.
I see Greg taking feverish notes back there, so.
Good. So that's the gist of that one. You know, it's up to you to prioritize what you want to do. Obviously, if we do have a moratorium in place, or if there's a renewed moratorium, then it would likely need to take priority because we have a ticking clock at that point. Right now, you know, basically, if we were to get an application, then they would be under the current standards. But accept any applications until we finalize everything or moratorium expires.
Yeah, so for my calculation, that was at the June 18th board meeting, and they said a 180-day moratorium.
Well, that seems unusual, but yeah, that would have expired. So that's something that I will relay to the board. So do you want me to go through each item, or just kind of a brief summary, and then you can kind of discuss it in terms of like a prioritizing? I mean, how do you want me to?
This, I think the first two items should be the first two, and then, once we get done with that, then we move. I know these are, because it's easy, if you put a lot of these things in meetings, and we've done this.
Yeah, we've done
Ross,
that.
you
That's
know,
why, that's how the
and
list is so
then
long.
we don't get anything
But-
done.
But what I want to say is, it's not, item number 2 is not necessarily the second priority. I think
No, I
marijuana is
meant,
number 1.
I meant solar, wind, and battery.
Oh, put that
ordinance
back in
plus the
Okay,
I would
yeah.
say-
MMA.
I would say
ones,
solar.
but-
Yeah, so it would be specific to the
Sorry.
overlay district map,
Yeah.
because they did approve the text amendments and did not, recommend to send those back for further review. It was specific to the map itself.
Okay,
Um,
so we just review the map and
Yes.
and figure out where we need to-
Discuss it with Laura, and,
Yep.
take a look at the recommendations, kind of start from square one, how we evaluated and determined, what are the appropriate areas and all that good stuff. So, I mean, I think that that's a good start. I mean, those, I think, would probably be the most common sense priority items if everyone is on board. So that's a good start. And I think that we could do those concurrently. Okay, sign regulation is a pretty complicated one. That goes back many years. When was that ruling? Like 2015, I believe. There was a Supreme Court ruling that requires that municipalities, can no longer regulate signs based on content. It needs to be content neutral. This is something that's been tossed around at the Planning Commission for many years, gone through the process, review process several times, and never really ended up getting anywhere. So that's something that we should revisit at some time. I've done some research. There's very few municipalities that actually comply with the Supreme Court ruling that I've seen, so there's not even a whole lot of example ordinances out there. Not to say that there aren't any, but it is a challenging topic, and it may be something that we'll need to rely heavily on our legal counsel, because it is specific to that mandate by the Supreme Court. It will be a major project. So far, I'll leave it up to you to determine how we've been dealing with signage in the township under our current standards. A lot of the things in there, like if I get a complaint about a sign, I can't necessarily enforce because our ordinance isn't really enforceable, but you should determine how high of a priority is it.
Ross, is it pretty common, complaints about signs?
No,
Okay. The big issue is they're
Around
tacked up
election
on
times.
telephone poles and stuff, but.
they've been worse in the past.
Yeah.
But I'd say, only 2 or 3 a year on average, max. There, years back, it was a little different, but since then, it's settled down. So that's the gist of that. We have an ordinance, but our ordinance is, for the most part, unenforceable. So I don't know how high of a priority it is to you. Like I said, it's been working, but that can change at any given moment, So that's what I've got for that. Moving on to sightline and building heights. Now, this is another pretty sensitive topic. Right now, we do have standards specific to lakefront properties, which are, they're not really adequate in anyone's opinions because they're too vague. We don't really have any set standards or criteria for determining when a sightline issue exists, other than just kind of arbitrarily saying, well, I think that'll block the view. We don't really have anything pertaining to vegetation. It's specific to structures, principal and accessory structures, and it's just something we want to look at. You know, it's been discussed in the past. Is this something that we want to regulate? Some people have that opinion. A lot of other people have the opinion that, yes, we do need to regulate, but if that's the route that we want to go and we do want to regulate, then we will need to do some pretty in-depth research on how to do this to where it's not going to be challenged in a court.
And I think you did a bunch of work with setback idea.
Yeah, we started with setbacks
Yeah,
and
and I do have some data that I can bring to the table when we get back into this.
current
discussion.
setbacks on per lake.
Yep,
We started that one.
Yes.
Didn't get very far.
I think
So, I mean,
every other way to do it is gonna be subjective at some point. Right?
exactly, and that's where the
Besides
question
the
comes
setback.
up, so that's just a topic that we will need to tackle at some point. It's mostly a sensitive topic when it comes to lakefront properties, but it may also be a topic.
Well, it's only currently regulated for lakefront properties, correct? Yeah.
When we previously discussed it, there was the argument as to, well, what about someone else's beautiful ravine or, you know, view of a river, stream, whatever it might be, farm field. You know, if we're regulating it particularly for one area, do we need to also consider other areas? Is that really fair? Is that? So there's a lot of different ways that you could go with that, but it is something that, you know, kind of fell off that we should get back into. Open space requirement for clarification for CDO and OSP. So CDO is the cluster development option, which is required through the Zoning Enabling Act that we offer that. It basically allows a developer to come in if they're doing a site condominium or something along those lines. They could cluster develop, so we could allow for higher density units as long as they set aside a specific amount of open space area, parks, that sort of thing for recreation to be consistent with the rural character. And OSP is very similar. That's open space preservation option. That's also a different option allowed by the Zoning Enabling Act. The reason that that is included on our list is because we noticed during an application for a site condominium project maybe a year and a half ago that there may be some deficiencies. And it's not that there's any major problems that were identified. It's more or less housekeeping. Clean them up, make sure that they're still consistent with the current standing of the law, and see if there's any way where we can make improvements, tighten it up, or clarify. So that's a housekeeping item. Outdoor lighting standards, so that came into play after the board adopted the residential outdoor lighting regulatory ordinance. And we did want to go through the zoning ordinance at some point, just to identify all areas where residential outdoor lighting may be mentioned, to just make sure that there's consistency, that we have a good flow between that regulatory ordinance that was adopted and our standards in our zoning ordinance. So that again would be a housekeeping item. It's not something that comes up too often. It always could come up, you never know, but that is just something that we never really completely picked up. We did have it on the list, but we never really got to it. Next one is conditional rezoning standards. Same sort of deal. We did have an application for a conditional rezoning about 2 years back, and that kind of just made us think, well, we should look at these, make sure that we've got as much restrictions in there as possible, that we're complying with the law, that we don't get ourselves into any trouble if we do receive another conditional rezoning application, which is not a common application. Again, never say never though. So that is, again, kind of a general housekeeping item. Accessory structure standards and ADUs being accessory dwelling units. Now, this is something that's been kind of discussed, tossed around back and forth for, the last probably, well, since I've been here. We frequently have a lot of questions, concerns regarding, well, both basic accessory structure standards that haven't been looked at in well over a decade, which is, are the numbers right, are the sizes right for the zoning districts based on, existing development patterns? Is it okay for us to say in R1 that you are restricted to an 800 square foot accessory structure or 1,200 with planning commission approval, even if you have a 15-acre R1 lot? Just basically a lot of little pieces that are missing that should be included. I could definitely provide a lot of insight into that because I see it day to day as far as applications, what people are trying to do, the problems that they have and whatnot. So the general standards, size, yard location, setbacks, those general accessory structure standards is one part of that. And then accessory dwelling units is something that the township had sent out a survey because we were getting actually a high volume of calls due to the cost of, senior living facilities, both the cost and then also the detachment from part of the family. A lot of residents with a lot of property, saying like the agricultural type districts, they're just looking for, I want a granny pod or a mother-in-law suite. Those are commonly used terms to describe ADUs. That's just something that we wanted to discuss and kind of consider, is it right for our community? Is there a way that we can allow for it with restrictions to where it's not going to create any nuisance factors? That's another thing that municipalities throughout the county and the state have been looking at and considering, and many have adopted them. Both in higher density and low density communities, so it's a pretty hot topic still. That sums that up. Cemetery standards. Now, we do have a few cemeteries in the township. Most are very old and township maintained. It's rare that we would see an application for a cemetery, but as you know, years back we did. And we looked at our standards, we looked at the county standards at the time, and we realized that, hey, nobody's applied for a cemetery, and I mean, at that time.
Scott, can you keep it down back there? You're disrupting the meeting. They can't hear you.
Hear us what was whispered?
Yes.
So like, I mean, that was like 3 or 4 decades that I think us and even the county looked and reviewed their standards. So we wanted to kind of, at some point, circle back with the county, kind of work with them as a coordinated effort to see how we should regulate a cemetery special land use moving forward. It's just been a long time. Again, that's kind of a housekeeping item. It is something that we will want to discuss at some point. Though, well, I'm not going to say anything about the chances. I mean, you wouldn't expect to, the application, but you never know. Limited lot waivers. This is it's a pretty hot topic when it comes to like lakefront lots and smaller lots and subdivisions and site condos that just don't have the yard space to store what they are permitted to store per the zoning ordinance requirements. So like for waterfront properties, you're only supposed to store the boats in a particular yard location. With a lot of lake lots, there's both the limited size of the lot, access to actually get around to the back of the house with a boat, and then also slopes and those sort of factors to consider. So we did want to look at that, see what we can do, see if there's a way that we can amend the standards in our in each residential zoning district to kind of alleviate the need for these limited lot waivers, and or consider modifying the limited lot waiver standards to just make it easier for people. I mean, it's not a difficult process. It's an administrative process to get the limited lot waiver.
Okay, that was my question. So that's up to you, DD.
Right.
Someone comes to you and you can give them a waiver on that?
Yep.
Okay.
So So we just want to look at that because it's also been many, many years since we've considered that. And since that was put into place, there's been a whole lot of development and, you know, the lakes keep getting packed tighter and people get more stuff. So, especially with limitation on accessory structure sizes and whatnot, that's become a pretty regular issue. Temporary dwellings, so we do have provisions to allow for temporary dwellings under a number of circumstances, natural disasters, that sort of thing. I mean, fire, damage, storms, etc., or during construction. Both of them do have procedures that they need to go through. Well, in the case of disaster, I can administratively issue one, but it's only for, I believe, a 3-month period. So for them to extend it, they actually do need to come back in front of the planning commission and ultimately get approval through the board. That particular item is, it's almost a checklist of criteria that you're looking at. You need to get health department approval, you need to get, you know, a few other minor little things. We just kind of wanted to look at that and see if there's any way that we can improve the process.
Ross, and I think there was one last year, was it?
There was
One for a fire, but
Yep.
have they ever completed it within the 3 months?
No.
So, yes, like that.
I mean, for natural disaster, especially given like in recent years, no, that's not a realistic time frame. We need to take those things into consideration. Then moving on to the environmental study. That's a pretty broad one. That's another housekeeping issue. It is something that we want to look at because it is something that we can require for a number of applications, specifically the bigger applications such as rezonings and certain special land uses that could require the environmental impact study. The purpose of including it on the action list is just to tighten it up, make sure that we can require it whenever possible, as much as possible, in order to preserve our natural resources.
Housekeeping.
Yep, housekeeping.
Very good.
Thank you.
Any discussion from the planning commission on any of these items?
Well, I would see one that's missing. During the master plan, there was a discussion to ensure that the ordinances for the new master plan aligned with the guidance in the master plan. And so I don't see that on the list to go through the language on the master plan to align to the ordinances that we have to ensure that the ordinances are up to date in support of the master plan. Does that make sense?
Yes, so the master plan, we are required to create one every 10 years, revisit every 5 years at minimum. It is designed as a reference guide to allow us, we'll want to take all of that account when we are amending our ordinances. It's not required that we go through and we amend our entire zoning ordinance specifically to be consistent with every single item in the master plan. It's just an item that we do want to consider when we are making amendments. That's not saying that it can't be done, I'm just saying that is the typical use of a master plan. Not every 10 years municipalities don't go through and revamp all of their ordinances. That's not only not required, but it's very, very, very costly. So it's something that could be considered, but that, if I'm understanding correctly, would be basically going through the ordinance line by line, which is 500 and some pages in the zoning ordinance. We need to make a lot of changes, but we could scrap it all and start from scratch, but do we want to do that, or do we want to?
That'd be so expensive.
No, what I'm saying is this was a topic that came up because I was at most of the planning commission master planning discussions. Mm-hmm. And it was a topic that was brought up a number of times that based on the types of changes that were incorporated into the master plan, there was going to be some effort to try to understand how that would impact proactively the ordinances, and then rather than reacting and having inconsistency with a ordinance that doesn't apply to the goals over the next 5 or 10 years or 20 years with the master plan, was to revisit that proactively.
So one thing that if the planning commission wants to do is go through the entire ordinance and try to identify areas that, may not be consistent with the master plan. In general, I mean, the whole, the big picture of the master plan is very consistent with our previous master plan and the previous one before that. It is, we want to maintain rural character. People want things a certain way. We got a lot of survey responses. In my opinion, there's not a whole lot that I would consider inconsistent with our ordinances.
Ross, one that I'm thinking of specifically was at Lake Urban. There was like something that didn't line up on the future land use map and the master plan and then the zoning districts and the ordinance. And we made a change. We changed the ordinance.
That's the CDO and OSP here.
Number 4.
But that was within those articles, those ordinances? Wasn't it something just, I thought it was something general in the zoning districts.
So when it comes to the conditional rezoning and with the CDO and OSP, part of that is to take into account the future land use map designations to determine the total density. And to my recollection, that was not officially changed. It was just, it's on the list here.
No, but we made a zoning ordinance amendment during the Lake Urban application, correct?
That I'll need to, I'm totally not recalling.
All right.
I know we talked about it.
Okay.
But yeah.
So do we want to add that to the list? I mean, we got a long, huge list now. But
Yeah, well, I'm not, I mean, just since there's a list.
since there's a list,
Since there's a, well,
so
if
in-
you're-
We'll want to
if-
add on
so-
specific topics for sure, just so that we can prioritize.
yeah, yeah.
yes, I mean,
I think what you're saying makes sense, but if we do it in a specific way, like this ordinance.
I'm not talking about a full overhaul of all the ordinances, but I think that, Ross, you would probably say, if you read the master plan today and with your knowledge of the ordinances, say, we may have, you could probably in about 20 minutes say, we may have risk in these ordinance areas, and then narrow that to go look at them and to do a cursory assessment of them, then that's what I'm talking about. It's not about with a intent to rewrite every ordinance in the big red book. I don't think that's the goal, but just as an idea.
Yeah, identifying those topics, I mean, it's definitely not a 20-minute thing. That's a very involved process to go through and compare it to the entire zoning ordinance. But if there are particular topics and we are holding regular workshops, that could be a continuing topic that we discuss.
Sure.
Hey, are there any more items that we found in the zoning ordinance that we want to add to the list based on the master plan? You know, we can have that as a continuing topic if everyone agrees on that.
yeah, and I think an important part is to have that list and bring that list up. Like you mentioned, okay, maybe Lake Urban, we just put it on the list.
Yep.
I thought we'd change the ordinance, but
Right.
either way, we discussed it, and that's come up other times in different applications, that maybe this ordinance isn't real tight here. But we just kind of put it on the list, and it never came back to it.
Yep.
So now we need to like keep a list, and I believe that you can keep that list,
Yeah.
and then probably plan to revisit it every so often, if we can get, you know, during
As
the
you guys
workshop.
decide, we can do it every workshop, we can do it every other meeting,
Okay.
we could do it once every 2 months, totally up to you guys, but yeah.
Well, it seems like if you add at least one of these or maybe 2 of these to every meeting that we have formally, they seem like they're not, other than the MMMA caregiver being a pretty heavy lift still.
Some of them might be pretty quick and easy.
You may be able to knock this list down to nothing rather over 6 months. And
I don't know, we spent how long on pool?
Yeah, no.
How long on pool covers, Ross?
Yeah.
Pool covers,
Yeah, how many months was that?
way too long. For just a few words, but that's the legal process, I mean, it does take time.
Yep.
Yep.
And
takes
we
time.
also don't want to get too overloaded with the number of topics that we're working on and ongoing, because then you lose focus.
Well,
So that's the purpose right now of this discussion, to try to prioritize and see
Sure.
what do we really need to get done in the immediate future, and then we can start tacking on additional items as the planning commission sees fit.
very good.
So I think what I've got so far is that you've, I'll make sure that we have a consensus, but I've identified that the two biggest priority items are gonna be the MMMA regulations and the overlay map. Does everyone seem to agree with that? For the most part? Okay. So I'll work, once we do the election, and I have a subcommittee to communicate with, we'll talk about what we're gonna have on the agenda for next week and so on. We'll definitely have extractive industrial. I'll need to communicate with Laura to see I'll need to communicate with Laura regarding the overlay map, and we'll need to talk to the board about whether or not they want to hire her on also for the medical marijuana. So
Sounds good.
That's my immediate plan here. Does that sound good?
It sounds good to me.
Yes.
I mean, a lot of these items come from the board, and I don't know, before we had a joint board meeting, and that's where we talked about them, so I would imagine maybe they call one of those.
We'll probably have one of those in
So-
the future.
Are we all good on this item? Next item of business, election of officers.
So for this item, all that we need is, per the bylaws, we just need nomination, and then we can just take a vote.
One question I had, Ross, is per the bylaws, we're supposed to vote on this in a regular November meeting.
Correct.
So will these appointments go until next November meeting, or for 1 year as
It
specified?
allows you to do a year or November, up to you.
Okay, just a thought during a motion.
So, yeah, what you're gonna wanna look for now is just, recommendations or if anyone wants to recommend anyone for the position, then we can just take a vote on each one.
I'll nominate John for
Yeah, I recommend.
Yeah.
Chairman, the guy with the beard, John.
Absolutely.
So do we want to do these one at a time?
Yeah.
Okay.
So,
Is there support on that?
I'll support that.
So we have a motion and support to nominate me as the chairman of the planning commission. And for what duration do we determine? Until next
do
November
it.
meeting and get us back onto the bylaws?
I'm in favor of that.
Yeah.
Okay.
That way we're
Until next-
consistent
until
and
next
public
November meeting.
knows when.
Right.
All in favor signify by saying aye.
Aye.
Any opposed? That motion passes. So on to vice chairman.
Nominate Chris Ropetta.
I nominate Kevin Ross.
Well, we got one motion on the, well, I guess it wasn't a motion.
Yeah, it's just a nomination.
Just a
at this
nomination.
point, yeah.
All right. What was your nomination?
Kevin?
Any other thoughts, anyone?
We just need to vote now. and see
Yep.
what's-
Well,
Right.
what's that?
I think we just need to vote, and whoever gets more votes is the
Call the
is
motion?
vice chair, right?
Somebody make a motion.
Yeah, well, or someone can just make a motion.
Yeah, sure.
And we still got secretary too.
Yeah.
I mean, not that, there's differences in those duties, but,
Yep.
you know, there,
Yeah.
anyone want to make a motion?
For the.
For vice
Move
chair.
For vice, okay, yeah. I'll move we elect Chris as the vice chair, since he's on the board as well. So, that worked well with Kurt.
Any support?
I'll support it.
Motion and support to nominate Chris Ropetta to vice chairman of the planning commission. All in favor signify by saying aye.
Aye.
Aye. Any opposed?
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 Three's opposed.
Three? Yeah. I don't know what to do there, Russ.
It's all there.
I don't know what to do here. It's 3 and
Well,
3.
we're gonna have to,
Come back for another
regroup it.
motion.
So, right now, we got nominate for Chris to be vice chairman and Kevin Ross to be vice chairman.
Yeah, so
Would one of you want to be secretary? Any other
No.
thoughts on that?
I nominate Bill for secretary.
Well, we can move to that one next, or we can do the secretary now, if you want. We're still gonna have to come back to vice chair. So, Ross, does that say majority of the planning commission members, or does it say members present at the meeting? I guess it really doesn't matter
It
either
does
way,
not specify.
because we have 6.
Yeah, we only have.
Well, and
6.
and we have a vacancy,
Yeah.
so I guess it doesn't matter.
It does not specify.
Yeah, Greg, go ahead.
I think you need to table it until you have your
Yep.
seat filled for a tiebreaker.
I think, yeah, I think maybe we move on to secretary, that way, I don't plan to be gone, but if I was gone, then we would have someone else
Yeah.
for
Yep.
the next meeting. I'll be here, but, so we can table the vice chair nomination or election and move on to secretary. We had discussion of a nomination for Kevin.
No, I'll nominate Bill here.
Oh, Kevin nominated Bill. A motion? I'll make a motion to, can I do that? I can do that.
Yeah, you can do that.
I'll make a motion to nominate Bill as secretary of the planning commission. Kevin supported. Motion and support for Bill Wood to be secretary of the planning commission. All in favor signify by saying aye.
Aye.
Aye. Those opposed?
No.
One no. Motion carries. Okay. So we will table election of vice chair. What's the correct term? Table definitely, which would be the next item of business, old business on the next regular meeting.
Yep, and if you want, I can see, I mean, timing-wise, we might be able to convert the workshop to a regular meeting to do it then. But, I mean, or did we want to wait until we had?
Well, I mean, if someone wants to,
I could just do it for January, I mean, what do you guys think?
Makes sense to do January.
what's everyone's thoughts?
Well, I don't know if we'll have, I don't want to put you on the spot, Greg, but I don't know if we'll have a new commission member in January or. how's that?
January you'll have one, right?
Well,
I don't know how that's looking. I know you had a pretty good timeline established,
I
but.
think we'll have somebody at the next board meeting.
Okay.
Yeah, but not by next Wednesday, right?
Well, the next board
I mean,
meeting.
unless the board doesn't like anybody,
All right, so is the next board meeting on next Tuesday?
Tuesday.
and I based.
I'd say let's get it going. Is everyone going to be here?
I can try to convert it, I just need to verify a quorum and get everything posted, you know.
What do you think? I say we just get it moving.
Yeah, I
Because
think.
the subcommittee is pretty important for any potential incoming applications.
It's pretty necessary.
Yeah,
Greg had a couple more comments.
go ahead, Greg.
I wanted to just say I based my tabling on your split decision, based on a ZBA meeting where we had the same problem.
Okay, I understand.
We just tabled it. I don't know what else you can do.
Well, someone could nominate someone else, I think, if they wanted.
The
And,
whole thing could change. Yep.
but I guess for now we'll table it. And Ross, did you want to discuss the workshop meeting now? Or sometimes we discuss that in miscellaneous
That would be
business.
helpful. I mean, who's able to attend next Wednesday at 6?
I'll be here.
I can,
1, 2, 3.
you
Stand
got
by.
me, right, Russ? I'll be.
I got you. Garrett?
Wednesday,
Check your calendar, stand by.
Yep.
yeah.
I mean, well, if we've already got 3 or potentially 4, then that's going to be more than enough.
Garrett said, yeah.
Yeah.
Greg, can you see if your new appointee can be at the meeting next Wednesday?
I'm pretty sure they'll make it.
Okay. All right, so we'll change that to a regular meeting, right?
I will do what I can, should be no problem.
Okay, that item is done for now. Next item, call to the public for any items at all. Scott?
Long walk. Sorry, I didn't know you heard me whisper back there.
You don't whisper.
Well, what's I can do? I'm trying to get caught up because, you know, the meetings are supposed to be at 7 o'clock. 7 o'clock, not 6, workshops at 6, but you know, just par for the course around here. So anyways, the ordinances. Last master plan, all we do is, mostly people probably don't even know half the ordinances we have on record. So we just went through them page by page, and you rubber stamp the ones that you don't need to change, and you can either alter or remove or add on as you go in certain areas. It's that simple, because there's a bunch of them I'd like to get changed, put recommendations in, like the fire, the burning, the kids, the cats. I mean, I've eliminated 15 cats in my yard, and I live on a lake, and I still got 5 of them running around. We gotta have some kind of ordinances change around here. People, it's just getting crazy around here with a lot of stuff. And this burning ordinance with the darn, if you own so much property you can burn, I can have a lot on my lake. The guy next to me can burn with 3 acres, but I can't. Come on, this ordinance, some of these ordinances gotta be changed. So a lot of guys, you might be wanting to know what your ordinances are. It's just that simple to go through them and change them. It's not that difficult. We did it before. You guys were here, I was.
Thank you for your comments, Scott. Feel free to email us the comments that you have on the ordinances.
No, when we get to,
I mean,
you guys were discussing the committees and stuff, we can work on it. That'd be
All right,
a great place to start.
In regards to the burning ordinance, that's a regulatory ordinance, correct? So
Is it
that's,
regulatory?
that one you need,
Yeah.
That's through the board.
that one you need to take up with the board.
Yeah, no, that's what I'm saying, that's one of the things I want to see changed. I don't burn, I got spot and dump on things, but they still, the people on my lake, they got less than an acre and they're burning leaves, which don't bother me. I mean, the only reason I don't want them to burn is when it's a nice day, like I ain't got my air conditioner on, and I got windows open. I mean, other than that, I ain't got no problem with people burning. The problem with our township here is we don't ever have an issue unless 2 neighbors are fighting, and the one calls just to get the fire department on the other one. But like I said, there's a lot of things hopefully we can get changed here. Talk to you later.
Thank you for your comment. Anybody else?
Yeah.
I think Dean is coming up.
I know, Dean Haas. I just want you guys to know, you're in violation of your own bylaws. Bylaw 4.01 on your meetings, your regular meetings on Tuesday are required to be at 7. So you guys might want to check on that before you make it to 6 next time. It is in your bylaws. If you want to change your bylaws, we can do that somehow or another, but at this point, the bylaws do state that your regular meetings on Tuesdays are to be at 7 o'clock. Thank you.
Understood. Thank you for the comment. Go ahead, Tina.
Jeanette, Tyrone Township resident. Yeah, I would like to know why this was changed to 6, and then only yesterday the calendar on the website was changed. So people looking at the, oh, yeah.
I can speak to it.
Go ahead, Russ.
Thank you.
So the only reason that we had to move it up is because Mr. Fisher, our attorney, was unavailable to attend the meeting otherwise, so we would not have had him there to talk about EI, which we wanted to keep the ball rolling. We did post everything in terms of compliance with the law. The bylaws may be another thing, but everything was legally posted in terms of the notice.
It doesn't matter, Ryan, it's a bylaw. We need to look at it.
I was not saying anything, I'm just saying it was in accordance with the law and was legally changed, so.
Thank you, but something has to be done to coordinate all the places, because some people get their information, they go to the calendar. As I was told by this previous supervisor, everything is there that you need on the website. Well, if you go to that calendar, it only got changed yesterday. So that's just something, a process maybe, when you change time, you know, what needs to be done. Okay. And also, this won't be a popular comment, but I'm going to make it. Hope you guys think about when you're nominating someone to take chairman or secretary, you probably want to nominate somebody that actually attends the meetings. So take a look at the attendance. Also, I'd like to bring your attention to our neighbors, Conway and Cohocton Townships. If you don't know where they are, if you go west, then whatever way is west, the next township is Deerfield. And then you've got Cohocton, keep driving, and you've got Conway. I have friends there, and they stand to be surrounded on 3 sides with solar. So I hope you guys know about this. Do you know about the application that they got? And I hope that you're going to give up your silence with that you can actually communicate. I mean, what's so hard to say whether you know about this or not? Okay, I'll take it that you don't know about it. So they've been presented with an application. It's going to be 2,200 acres. That's 3.5 square miles of solar. And they don't care that the PA, that law has come out. They don't care that anything's in litigation. They're going for it. So these communities are devastated because they know that people living in those areas will be ruined financially. Not to mention the ruin they'll experience to their health and the environment if they stay. But those negative effects will touch people for miles. And if anyone thinks that's not going to affect us in Tyrone Township, think again. I would like to know if Tyrone Township has received any such letters. And I'll tell you, the Cohocton Township and Conway as well, they published the letter. And they sent a notice and published a notice to all of their residents, and they said, in the interest of transparency and the township's commitment to keep residents informed. And then they told them what was happening. And this letter is by Headland Solar, and guess who they are? Ranger Power. Do you guys know who Ranger Power is? You know Lennon, north of us, about 30 minutes? Devastated that area. They've been out in Fort Gratiot, they've been all over. And guess what, they're not even a Michigan company. And they're just taking in the money and they're ruining neighborhoods, communities. So I say this because I think there's still more that we need to know. We need to, I believe we need to have Laura back in here, and I'm glad that this is on the agenda. And maybe we can get some of them, can I submit some questions? Do we have a chairman that's going to actually look at emails? If I send them to you, will you answer? Will you read them? If that's the case, I would love to send you questions that I have, because I've been immersed in this. I've talked to the people, I've talked to the supervisors, planning commission people out there, and they tell me what they know. And I really feel like you guys haven't been fully informed on what's been going on. Anyway, that's my little thing tonight. I'm very concerned about them. It makes me want to cry what's going to happen to them. And again, our little solar, our overlay part, that is not, we told you that it wasn't sufficient for what they're going to want. Now it's coming back and saying that, and we're going to have to look at it again. What are they going to do? They're not waiting for any law or any litigation to happen. They're already going to Conway and Cohocton, and they said, we don't care. And they, you know what else they said in their letter? If you don't have an overlay, an area that agrees with what we say, we're going to the MPSC. They will just plow over them and go there and guess what? You guys may not know, I know, we have landowners all over in Tyrone Township that have signed leases. They're ready for these developers to come in and say, we're not looking at this overlay, sign you up. So, and even with the extractive industrial, I ask, have you guys looked at other ordinances? I mean, you need to reach out to these other communities. They're very willing to share what they've done and their knowledge and you know, why reinvent the wheel? I'm glad that sounds like we have a really excellent lawyer for that. But when you're looking at things, reach out to these other people and ask them what they're doing, because they've spent a lot of time trying to protect their communities. Thank you.
Thank you for your comment. Go ahead.
Ed Murray, resident of Tyrone Township. After the information that came out from St. Clair County Health Department, I think it would be wise for us to contact Livingston County and see what studies they've done to see what's going on with this. We don't know enough information about this. I'd like to see all the details from St. Clair County Health Department, why they think this is very detrimental to all the residents. I think all of us need to know that. So before any decisions are made, especially when you look at the overlay map, and where the solar farm is surrounding Ore Creek and all the other little lands there, I don't understand it. I mean, the water's flowing there 363 days of the year, and it doesn't make any sense to put solar panels where you have an open creek that's really active. So I think it would be wise for Tyrone Township to see what's going on with this health department information and why they think it's very detrimental. We should have that information in our background so we can concentrate on making any important decisions. So I hope there's going to be investigative time spent on that. I'm going to try to find out the details, how they came up with this decision. Very curious about it. The other thing concerning cemetery regulations, a lot of things are coming up on that. And I think there needs to be a very active study on that, because farmers are limited on how many animals they can bury on their farm a year. I don't remember the poundage, but I think it might be around 3,000 max. And with all the open burials now that are taking place in cemeteries, I think we need to take a close look at that to see what rules, regulations. And even in Europe, they're having issues with their water supply now, because their population of dead people over the years is a lot older than ours, so they're having issues. So I hope there's a study involved with all this before you make any rules and regulations for the cemetery, to have as much information as possible to make good decisions, because most people here are on wells. I don't want to have the water affected for our residents, and I hope you do your homework on both these issues. Thank you.
Thank you, Ed. Any other comment?
John, can I just give you a reminder for?
Yes, go ahead.
Okay. Steve Bissell, Indian View Trail. Jeanette, Chris, you might remember a couple, 3 years ago, when the first time the medical marijuana thing, raises that. There was a lady, Rush, you might remember too, there was a lady, I think she was an attorney, that the group brought up from Ann Arbor as well. I'm not saying Laura doesn't know, but she was here from Ann Arbor, and she had a ton of information on all the goods, the bads, and the uglies about just state and federal medical marijuana laws. And since it's back on the list to talk about. I just wanted to give everybody a reminder that lady was extreme, I don't remember her name, but she was extremely knowledgeable as well.
She was,
and answered a lot
she was
of
the attorney,
questions.
the applicant?
No.
Whose
No.
attorney was it?
I can't, she wasn't.
She came as a guest.
She came as a guest and to provide just
Oh, yeah.
knowledge.
Okay.
Board meeting.
All right.
Board meeting.
Remember that, to the board meeting? I couldn't remember which meeting. Anyways, I thought she was super knowledgeable, so I just wanted to remind everyone as a reference. Thanks.
Thank you. Any other comment? Hearing none. Move to miscellaneous business. Ross, do we have anything to discuss, or anyone?
Just confirming that we are planning on holding a workshop meeting next week at 6 PM, and we do intend on converting that to a regular meeting to potentially consider electing a vice chair.
Will it still start at 6?
Yes.
I guess on that, Ross, we should try to have the meetings stick to the 7 for the
We
regular
should.
meetings.
This is the first time that we've ever done it since I've been here, and we only
Yeah,
did it so that we could have Mr. Fisher available. Because he had a city council
Yep.
meeting that began at 7.
Understood.
Otherwise, we'd be pushing it back. So we're just trying to expedite things.
Any other miscellaneous business?
Just the, Ross, I don't know if you send an email or as the zoning administrator, Greg could or somebody, but to Livingston County, right? Most of these solar applications are like, that were just mentioned, right, are in their county. I'm just wondering if they're doing anything similar to what St. Clair did, or maybe you've already emailed them.
I've been researching it and looking
Yeah.
into it. But, yeah, we'll so you want someone to coordinate with Livingston County specifically regarding,
Well, at a minimum, just ask what they've done so far, right? Because I know their planning
I talked to Rob
department
Stanford.
reviewed ours,
I
but,
talked to Rob Stanford pretty extensively about it when we had our
Yeah.
amendments going through, and he advised that ours were leagues better than anything else in the county. He didn't specify at that time anything relating to,
no, I'm just curious what their health director says, because the way this is going,
health
it's,
department for solar.
the health department, yeah, it's because as the way things are developing, it doesn't seem like whatever we make our ordinance, it's gotta be what the state says it has to be, right? And that's probably not where we're gonna be able to fight it, right?
But the health department can fight a lot.
But that's just a question, ask them
Yeah,
what they've
because
done and
the
where
health-
they're at.
I mean, they,
Because they have jurisdiction over it.
they have jurisdiction, and, you know, that's,
It's a question we can propose to Foster Swift, whether that gives us extra ammunition in addition to the ordinances and stuff that have been put in place.
but to what? To suggest to the health
No,
department how to?
to see if that's something we should pursue with the town, with the county, to see if they can help support
Yeah, I guess this.
from the county health department, right? Would be able to support additional study between Livingston County and St. Clair, who's publishing this information as well, to see if, because they also will cooperate with other counties as well, just to get the expansion going of information, right? And trying to see what can best put us in a position to fight against applicants who want to turn 3.5 square miles of Tyrone Township into a.
Well, also, if you get the county involved, that would slow down Deerfield and the other one if the
Yeah, Deerfield's got a lot
health
of,
department doesn't like it.
Deerfield's got it in all ag, which is probably 90% of the township allowed.
They're big time targeted.
Oh, yeah. Well, I guess, Chris, maybe you can bring that up on next Wednesday when Laura's here?
Sure.
So didn't we get the health department involved in the last cemetery also?
Yes.
I was gonna say I didn't.
And they okayed it, right?
Oh, yeah, they did, but at that time, they determined that their standards were very out of date as well, and,
So it's something we need to investigate with the,
they were working on it. I need to check on the status of it, but, I
Okay.
can follow up on that as well.
Any other miscellaneous business? Hearing none, could I have a motion to adjourn?
Motion.
Motion and support to adjourn the meeting. All in favor signify by saying aye.
Aye.
Any opposed? Meeting is adjourned.
Thank you, guys. How are you?
good?
Good. How are you guys? I didn't want to have to do this. I reached out to you guys.